Hello, everyone, and welcome to the Wills, Women, and Wealth podcast, where we lead you holistically from overwhelmed to empowered through estate planning. I am Elsa W. Smith, your Maryland estate planning and probate attorney, and the host of the Wills, Women, and Wealth podcast. This podcast is for women who value their health, their wealth, and the legacies that they are creating. Each episode is going to bring you interviews in the areas of finance, law, mental and physical health, and so much more. I'll also share educational episodes that answer your questions on wills, estate planning, and probate topics. We welcome your feedback. So let us know if you like this episode. This and all future episodes will be available on YouTube, Spotify, Google Podcasts, and Apple. Please leave us a 5-star review on Apple Podcast. Your review is going to help us get seen by more people who really need this message. If you're watching us on YouTube at Elsa W. Smith Law, hit the subscribe button so that you don't miss any of our upcoming episodes and that you join our growing community. Now, on with today's podcast. Our topic today is problems resulting from jointly held assets with your children. Now, today I wanted to share a few issues, few scenarios that illustrate why you shouldn't make children joint owners of your assets. As with all estate planning, everyone's situation is different, right? And in the end, you know your family members, certainly better than me. My mission here is to educate and empower you to make smarter estate planning decisions. However, my clients have shared these issues with me, either through firsthand experience or from what they've seen other family members and friends experience. So I've compiled all of those issues into this podcast for your benefit. For those of you who are taking notes, I should say, I want to give you a bit of a roadmap of where we're going with this podcast. We're going to cover first, adding children to your bank accounts. The second issue has to do with adding children to property deeds. And then lastly, we're going to wrap up with unintentionally giving third parties control of your assets. So having said that, let's go ahead and get started. Issue 1. Adding children to bank accounts. The first issue in this category, in this subheading that comes to mind for me is the increased liability. Your funds might be utilized to pay off your child's debts if they are sued, declare bankruptcy, or even get divorced, right? So to prove that the money in a particular account is yours and not your child's, and should not be subject to your child's creditors, will at the very least need to clear some significant hurdles. It's just very complicated to do. Another issue, another problem that comes up under this heading is, that public assistance benefits could be refused to your child. The government will check all available income and assets if your adult child becomes disabled and request Social Security and or Medicaid disability benefits. The claim for benefits from your child may very possibly be rejected if they are included as a co-owner on your account, and depending, of course, on the the value of the account, the assets, the value of the account. That's what I meant. Before being eligible for Medicaid, SSI, or other forms of government assistance, they might need to drain down your money, your assets, in order to pay for their care if they're involved in an accident or experience a sudden health issue that leaves them disabled or incapacitated. The other issue in adding children to your bank accounts that is quite a touchy one when I raise it is that your child can wipe out your bank account, right? So although the initial intention may have been, that your child wouldn't touch the monies in the account because it was still your money, the temptation may later raise its ugly head. And all it takes is for your child to have a crisis, a job loss, a health issue, an addiction, or just any kind of crisis, right? The temptation becomes too great. And at some point, your child may start to tell themselves, they may start to believe that you would have wanted to help them out and wouldn't mind if they dip into the account, a little bit, and then a little more and a little bit more until there is nothing left, right? So there are no restrictions on the checks or withdrawals that can't be made by a joint account holder. Another issue, while it's not difficult to add a joint owner to your account, taking them off is a nightmare. In order to remove your child as a joint account holder after you've added them, you must gain their permission and get them to sign. Or, as many banks will have you do, you're going to have to close out that account and open a new one that's only in your name. Again, lot of hassle. Another issue, another problem in this under the subheading is, that all the money in the account goes to the child named as a joint owner, despite what your will says. When you pass away, the joint account holder gets that money in the account. They inherit that money in the account, which may not be what you intended per your last will and testament. So any joint account you have is a joint account holder is a direct beneficiary who receives those proceeds without going through the probate process, right? That implies that if your intent was to, divvy out the monies that were in that account to not just the child that was a co-owner, but say if you have other children, to divvy it out amongst the three of them, they're not getting it. And, they're not entitled to because you've named the one child as a co-owner. And that one child can do whatever he or she wants with the monies in that account. I know. Issue 2 is adding children to property deeds, right? Why is this a problem? The first thing you need to consider is that you risk losing the step up in basis. Now, what am I referring to when I talk about a step up in basis? When beneficiaries receive assets from benefactors, the step up in basis tax provision, at least as it reads right now in the code, aids them in locking the cost basis of these assets. So before passing to heirs, real property, may see a dramatic increase in value over time, right? So in contrast to the date of acquisition, the date that the property was purchased, versus the date of inheritance, that difference is what determines the capital gains liability or the capital gains exposure when that property is sold. Now, it's crucial to know that taxes on assets donated prior to death are subject to the original cost basis. So a step up in basis occurs only when a benefactor dies. Now, I can just imagine, if I could see you right now, that some of you are just your eyes are just glazing over right now. So let me give you an example. A house might have cost, say, $10,000 in 1950. Your tax basis is the amount that you paid for the house, right? So if the beneficiary were to sell the house at the time of the owner's death, say in 2022, and at the value of $450,000, they, as a beneficiary, would be liable for a $440,000 taxable capital gain. So that's 450 minus the 10. That's how we get the 440. All right, so by employing the step up in basis, the beneficiary's adjusted cost basis is changed to the $450,000 value of the home at the time of death, and they are spared from inheriting the massive unrealized capital gain burden from the previous 70 plus years. If you make, however, the beneficiary a co-owner while you are alive, that beneficiary's tax basis will be the same as yours. It's that $10,000. And they will then have a much higher capital gains tax exposure. Not something that you want to leave as a legacy. Now, so to review, when calculating the capital gains tax due on an asset, the cost basis is crucial. One pays more in taxes the greater the difference between the cost basis and the selling price, right? So while you may have had the best of intentions in wanting to add your child to a deed, be sure to consider the tax consequences before doing so. The next issue in this, within this heading of adding children to property deeds, is complications that arise if you want to sell your home. When you include someone on your deed, they legally become a co-owner of the house, which presents another unsettling complication. You will need their consent in order to sell the home, obtain a mortgage, a home equity line of credit, for example. So it presents a lot of thorny issues. And the last point I wanted to mention under this subheading is that there is increased exposure to liability and creditors' claims. A fellow estate planning attorney had a client who lost her home during her daughter's bankruptcy. The client added her daughter to the deed of the home that she lived in for more than 50 years. There was no mortgage on the home. After adding the daughter to the deed, the daughter's employment was terminated, and she lost her health insurance. The daughter then had a serious medical emergency, and the resulting medical bills forced her into bankruptcy. Now, it is well known that medical bills are a major cause of people filing, going into bankruptcy. Serious illness, job loss, and bankruptcy could happen to anyone. You should consider these possibilities even if your child is responsible when it comes to their financial affairs. The third and last issue I'm going to cover in this episode has to do with unintentionally giving third parties control. What do I mean? What would you think of your son-in-law or your daughter-in-law controlling your assets? If the thought frightened you, it should. Let's say that you add your child to your bank account as a co-owner. Your child then creates a power of attorney that names their spouse as their agent. Now, a power of attorney agent steps into the shoes of the principal. So in this case, it's your son or daughter-in-law stepping into the shoes of your child. So if your child becomes ill and therefore needs to activate this power of attorney, that son or daughter-in-law would have control of accounts owned by the principal, in this case, your child. That's how your accounts could be controlled by your son or daughter-in-law. Something to think about. Now, I hope that these problems that I've highlighted raise your awareness of the importance of proper estate planning. While you may consider, a technique that you heard about, while shopping or talking to your girlfriends. You may consider that a neat, a nifty short-term solution. Our job as estate planners is to consider the long-term consequences of anything that you're proposing and to advise you accordingly. I certainly don't want you to, go it alone. It's not necessary, and it's certainly not necessary for you to DIY your estate plan. We help clients in Maryland and the District of Columbia navigate the issues that we covered today and so much more. We'd welcome the chance to help you do the same. I invite you to book a free 15-minute call with a member of our team. There is no obligation. I'm Elsa W. Smith, your Maryland estate planning and probate attorney. I want to thank you for watching this episode of the Wills, Women, and Wealth podcast, and I'll see you in the next video. Take care.